Okay, good evening. It is July 28th, 2021. Thank you for coming to our webinar this evening. Thank you for taking some time out of your summer schedule to learn about the importance of updating your estate plan, namely your will, your living will, your power of attorney. My name is John Benson from Penglase and Benson, where we help you document and transfer your assets before it's too late. Well, I want to thank you for coming to the webinar tonight. I know your summer schedule is packed. We will try and get this done very quickly for you so that we can get you back on your way. But it's a really important topic that we're going over tonight. As always, if you have just a second, go into the chat box on your Zoom screen and type in either yes or a Y or something that would indicate that you can see and hear us okay, so that we know that all the technology is running and that you are hearing everything perfectly fine. All right, we will get going. Being that okay, Bob, see that you're on, thank you. All right, I see that the technology is working, so we can get on our way. Again, thank you for coming to the webinar tonight. I do a lot of wills. I do a lot of living wills and powers of attorney every year. And the biggest thing that I notice is that people will do the document, they'll get it executed, and they'll say, whew, I'm all done. I don't have to do anything more. And they take their will and their living will and their power of attorney and they put it in their home safe or they put it in their filing cabinet or something like that, and that's it. It doesn't see the light of day again. And unfortunately, people don't realize that you have to kind of stay up on these. I like to equate an estate plan to buying a Ferrari. I tell people that if you were to sell everything that you own, you could probably buy a Ferrari. Well, a lot of people will purchase a Ferrari and they don't do anything with it. They put it in the garage as an investment and they want to make sure that the paint stays fine, it's not chipped, no one does any damage to the car, no one door dings it or anything, because someday they're going to sell it for more money. And they close the garage door and they lock it up tighter as a drum and they say, I'm done. And maybe 10 years will go by and they're ready to sell the Ferrari. And they open up the garage door and there's the Ferrari. The paint is still perfect. It's just under a layer of dust. And it's time to roll the car out into the light of day so that they can sell this Ferrari. And they jump in the car, they put the key in the ignition, they turn the ignition, and nothing happens. The Ferrari hasn't been maintained. The lines are bad, they're cracked, the gas has gone bad, the tires are flat. Had they just taken a few minutes each year to maintain the Ferrari, it would have been ready when they are. And the same thing has to do with your estate plan. People don't realize that if all you need to do is spend just a few minutes a year maintaining this document, and it's going to be ready should something terrible happen to you. Right now, all the people that we are storing their original documents for, we call them every summer, just check in on them, see how they're doing. And when we do that, one of the things that we're doing is we're reminding them to look at their document to make sure that it is up to date so they don't forget. I myself had to update our plan and at least look at it. And so it literally took about 30 seconds to go through the 3 documents that I had prepared for our family to make sure that everything was perfectly fine. And with that, with just 30 seconds a year, I get to sleep the rest of the year because I know if something should happen to me, my family's covered. If something should happen due to COVID and I'm in the hospital, I know that the assets can be moved around and safely protected or used. I know that if I can't make a medical decision for myself, that someone that I have appointed is going to take care of that, consistent with decisions that I would normally make. And so I get to sleep easily knowing that all those things are taken care of. And I want you to be able to have the same thing. And that is the purpose of tonight's webinar. So without further ado, what I want to do is kind of take you through the program and just show you why you would have to go and update some of your documents and also how you'll go about doing them as well. Okay, the big question that we have tonight for you is, does your estate plan need a tune-up? And this is all presuming that you have an estate plan to begin with. If you don't, that's a much bigger discussion that we need to make sure that you have an estate plan so that you are protected. That's going to be your main safety net. But we're going to assume tonight that you have one, and maybe you haven't looked at it in a while. Maybe you haven't looked at it in years, and you're wondering, should I do something with this document? What we want to do is make sure that we take the important step of securing not only your future, but the future of your loved ones as well. And that's what happens when you make sure that these documents are updated, that the future is always secure for your friends and loved ones. Have you created an estate plan to protect your loved ones in the event that something happens to you? If you have, and that's why you're here, great. But it's important that you remember to periodically review and update your plan. As you grow older, as your kids and grandkids grow, as your life circumstances change, it's likely that your estate plan will need to be updated to reflect those changes. So before we dive in, let's review 5 of the most important estate planning documents you should have in place. The first one, the durable financial power of attorney. Now, this document appoints an individual to manage your finances in the event that you're injured and unable to manage them for yourself. The durable financial power of attorney is simply a way to allow someone else to manage your finances in the event that you become incapacitated and are unable to make those decisions yourself. The power is granted in a document and is not only useful for you, but can really help your family in a time of crisis. If you get this document through our firm, we just call this a power of attorney, but I've seen lots of people call it also a durable financial power of attorney. It's the same thing. And either way, you're going to be able to make sure that the finances, the real estate, the personal property can be moved around in a lawful manner should something happen to you. Now, a durable healthcare power of attorney. Let's see, that we went. Yes, here we go. A durable healthcare power of attorney. Now, this document appoints an individual to receive healthcare information and make medical decisions on your behalf if you're unable to do so. A durable power of attorney for healthcare is a document that lets you name someone else to make decisions about your healthcare in case you are not able to make those decisions yourself. It gives that person is called an agent, instructions about the kinds of medical treatment you want. The next is an advance directive, also called a living will. And again, if you get this through our firm, they are one and the same. We combine these last 2 documents together and they're just called a living will. But some people, again, call them different things, and so we're trying to recognize that tonight. So an advance directive, also known as a living will, is a document which expresses your wishes in the event that you become incapacitated. Living wills allow you to make your own decisions to direct which types of life-sustaining treatment, if any, you would like to receive if you have a terminal illness or if you are in a permanent coma. I like to tell people that this document is going to end life as well as preserve life. Depending on whatever your beliefs are, you can have it drafted in such a way that it can be very clear that you want to continue using life-sustaining measures or not. The last will and testament, simply put, your will determines who gets your assets after you pass away. A last will and testament is a legal document that expresses what you want to be done with your property, including your money, after your death. A living will is completely different from a last will and testament. A living will deals with how you wish to be treated when you are dying. It has nothing to do with money or possessions. A personal property memorandum. How do you want your personal effects to be distributed? A personal property memorandum is a flexible and easy to use document that permits you to freely put together a list of your smaller tangible items, including clothing, jewelry, or pieces of art, to be given to your intended beneficiary. It is a separate document from your will or trust, and it is one that you will be able to prepare on your own and amend as many times as you wish, without the need for witnesses or a notary public. When people come and get an estate plan from our firm, we usually recommend that they have this included with the papers that we give them, so that when someone goes and they have to administer your estate or they have to move your property around because you're incapacitated, they'll have a checklist of everything that you have, so they know exactly what to be looking for. Because let's face it, do any of our friends know everything that we own, or where we have them, or what bank accounts we use, or what bank branches? So this document will allow you to do those things and make it much easier for your agents to be able to act. We recommend that you review and update your plan at least every 3 to 5 years. Personally, if you can do it more than that, I think it's better to do it more than less. But at the very least, every 3 to 5 years. And again, just the review of the document. If you review it every year for 30 seconds, and that really is all that it's going to take, you'll know whether or not you need to make some decisions that are different from what you did last year. But at the very least, every 3 to 5 years, you should be looking to make sure that the will is updated if possible. In addition, we recommend that you review and update your plan whenever you experience significant life changes. So today we're going to cover many of those key changes and explain why it's important that you update your estate plan after each of them. Marriage. Your spouse will be the beneficiary of your will in most instances. Will your spouse have decision-making authority in the event that something happens to you? Well, you need to make sure that you've made changes for that. Divorce. Will you remove your ex-spouse from your estate plan? It's something you're going to have to consider. Many people, they're so involved with the divorce and the pain that goes along with it that they don't realize that they have estate planning documents that may be leaving things to that future ex-spouse. And that could cause some problems. Maybe you want things to go in a different direction now. So while you're going through the divorce, it's important to update your plan to reflect the new changes that are going to be taking place. The birth or adoption of a new child or a grandchild. Will your new child or grandchild be written into your estate? So you want to make sure that if they haven't been included already, that you have them included so that once the birth comes, that there isn't any problems, and should something happen to you at the same time that they're born, that they're going to be able to receive a part of your estate, or God forbid something were to happen to your children, that your monies are going to be able to pass down to your grandchildren. If you move to another estate, you need to make sure that your estate plan is legally valid in the new state. I tell people, just because you are crossing state lines and moving from one state to another doesn't invalidate your plan. Your plan is still valid. However, you can't be certain that all the language and all the clauses that you had inserted in, say, a Pennsylvania will are going to be enforceable in New York, Florida, California, New Jersey. You don't know that maybe they have more or less favorable laws for you for estate planning purposes. So you need to go and make sure when you move that you take your estate plan to an estate planning attorney in that state and have them review it to make sure that everything that you decided on can be lawfully done in that state. When a child or grandchild becomes an adult, you need to consider how is that going to affect your estate plan if you are no longer concerned about protecting a minor child. For many people, they will put a condition in the clause that a trust is going to form and hold the property for that grandchild until they reach a certain age. Well, once they reach the certain age, do you need to extend that plan? Do you need to have that trust continue longer because maybe that child isn't making good decisions as an adult? You thought that they would make a good decision by age 21, but it just didn't turn out that way. So you need to consider, how those grandchildren are making decisions as to whether or not you need to up the ages for any trust that you have. Death or a change in circumstances of the guardian named in your will for minor children. If you no longer trust this person, you need to update your will immediately. And we often see many times during the year, someone will come on in and they'll say, I decided someone was going to be a guardian. I decided that someone was going to be an executor or a power of attorney. And they're making some really bad choices that concern me right now. I am concerned with them being able to handle this responsibility. I need to change that person. So make sure that you're looking at your documents, making sure that the people that you pick to do things are still the ones that are making good decisions that you want to have execute those decisions. Changes in the number of dependents, such as the addition of caring for an adult. If an adult child or a grandchild becomes disabled, for example, you may wish to update your estate plan to protect that individual. And people don't understand that sometimes if you were to leave something to an individual and they were receiving such things as a Social Security disability, you leaving them something in your will could prevent them from receiving those benefits. So you need to start making some decisions. Do I need a special needs trust for this person now so that I can leave something to them without invalidating their Social Security disability that they're receiving. So if there's a change in life circumstance with a dependent, then you need to start making some decisions that are going to be consistent with their best interest. If you purchase a home or other large assets, you need to consider making a change to your estate plan. These purchases have significant financial and tax implications and should be addressed in your estate plan. Large increases or decreases in the value of assets, such as investments. If an asset loses value, how does it impact your estate plan? That's something that you need to consider with your estate planning attorney. So if something is going up or down, it's going to have some tax consequences, and suddenly maybe what you thought you were going to leave to one person, such as a value, now you can't because the value has decreased. So it'll be something that you need to consider. Death or a change in circumstances of your executor or trustee. If your executor is no longer able to serve, you need to update your will immediately, and this will happen. We come home and we find out Uncle Larry or your brother has suddenly had a stroke, or God forbid they've passed away. You are so involved with getting through the grief and the shock that you don't realize that the estate plan needs to be updated because they were supposed to play a major role in your estate plan. If that's the case, again, taking just 30 seconds a year to review these documents will pick up these problems as they come along. If you start or sell a business, this decision likely has major implications for your estate. So if you are starting or selling a business, you need to update your plans accordingly to make sure that they reflect it. You don't want to be transferring an interest in a business that you no longer own. In the meantime, if you do own a business, you want to make sure that it's going to be running for the next generation, that the business doesn't close just because you pass on. Other common circumstances that require an update would be illness, death or disability of a family member, a change in your life or long-term care insurance coverage, if you or your spouse receives a large inheritance or a gift, and changes in federal and state laws covering taxes and investments. All of these would be reasons to be looking again at your estate plan to see if you need to make some adjustments. Now, we know that some of you may have some questions, and we love questions. We're happy to answer any of the questions. So if you do have any questions, again, please go to the chat function in your Zoom presentation and type in your question, and we will be happy to answer your question tonight. Or if you have questions later on, you can certainly contact us at any time, and we will be happy to answer your questions. Thank you for joining us today. We understand how intimidating and confusing this process can be. However, we cannot overstate the importance of having an up-to-date estate plan. If it's time for you to review and update your estate plan, we are here to help. So please contact us at penglaseandbenson.com. You can also email me directly if you would like at jbenson@penglaseandbenson.com. You can also find us on Facebook, Twitter, Instagram, or our YouTube channel. Or you can simply just pick up the phone and call us at any time, 215-348-4416. So again, if you need to contact us to either review, update, or even create your plan, call us at 215-348-4416. Email us at jbenson@penglaseandbenson.com. Go to our website at penglaseandbenson.com, or you can simply respond to any of our Instagram, Twitter, Facebook, or YouTube channel message sites. Again, thank you so much for joining us this evening. We know that your time is valuable, and so we don't want to hold you up too much. But if you have any questions, again, we are happy to respond to any questions that you might have. Now, one of the things that we find is that it's one thing to attend the webinar. It's one thing to create an estate plan. Again, it's another thing to actually take action and review it annually and make adjustments when necessary. And we're very concerned that, just like everything, when I call the people each summer and I say, how are you? I say, please, when you get a chance today, just take 30 seconds. Pull out those copies that I gave you a couple years ago. Just 30 seconds, go through them, make sure everything's fine. And if not, give me a call. I only think, you know, a fraction of those people are actually, when I hang up, they go and they actually pull the documents out and take a look at it, because we always say, well, that's an easy thing to do. I will do it tonight. And then you get home and there's dinner to make. There's the Phillies game to watch. Something's going on. You just want to go outside. You want to jump in the pool. And you figure, I'll do it next week. And next week just never comes. So we want to make sure that you take action. So in order for us to kind of see if we can get you to make sure that your plan is up to date, we're going to offer you a special this evening. Normally, if you want to go and update your existing will, if you have to make a change, we call that a codicil. Normally, we charge $350 to make that change. Tonight, if you find that you need to make a change to your will, we are going to knock for tonight only $100 off of that price. So it would only cost $250 to update your will if you have an existing will. Again, if you need to update a living will or a power of attorney, then usually those are going to be a little bit more because it's a little harder to change those documents. But again, just for tonight only, we are going to knock $100 off the cost of each of those. All you have to do to take advantage of this is just contact us at one of the communication channels I had mentioned earlier. Let us know that you want to update something, and that discount will be automatically applied. Let's say you don't have an estate plan. You're starting from scratch altogether. Okay, well then it's important for us to get a safety plan put together for you. So in that case, again, if you go through our firm, we combine a couple of the documents. So we do a will, a living will, and a power of attorney. And again, for tonight, there's going to be $100 knocked off each and every one of those documents if you want us to create a plan that is perfectly tailored for you. So again, now is the time to take action. We won't be able to offer this to everyone. We won't be able to offer this in coming days because there's just so many hours in the day, and we have to get these plans created for the people who contact us. So again, just for tonight, till the stroke of midnight, if you are interested, just contact us at 215-348-4416. Email me at jbenson@penglaseandbenson.com, or go to our website, penglaseandbenson.com, and you can contact us that way. So again, it's important for you to take action right away so that you know everything is taken care of. I tell people every year, just a few minutes a year will give you a whole year worth of sleep, because you'll know everything has been taken care of, that you don't have to worry about these things, and that the documents are ready to go when and if you need them. So again, if you can, take action. If you have an opportunity and you haven't done so already, again, as soon as you turn the webinar off, just take a couple minutes, pull those documents out, make sure that they are up to date and that they're ready to go, and make sure you know where the originals are. You always have to produce the originals on these things, and a lot of people will take and they'll leave them with their attorney, and then they have no idea where they are. They just have copies, and what happens to that attorney? For us, if we have the documents, what we will usually do is we will stamp your copy so everyone will know exactly where the original can be found. And we pull them out every single year and review them every single year with our clients to make sure that they are up to date. So again, thank you for attending the webinar this evening. We don't want to take any more of your time. If you have any questions, reach out and contact us at any time that you would like. We are here to help you, and I hope that you have a wonderful evening. Thank you.